All right, we're in Part E, uh, dispute and resolutions, and we'll go through the appendixes. Qualification certification of a locomotive engineer. All right, separate subpart E, dispute and resolution procedure. Review board establish any person who has been denied certification or denied recertification has and had his or her certification revoked believes that a railroad incorrectly determined that he or she has failed meets the qualification requirements of the of this regulation, who in making decisions to deny revoke certification may petition the Federal Railroad Administrator to review the railroad's decision. The Federal Railroad Administrator has delegated initial responsible for adjunction such as disputes to Locomotive Engineer and Review and Board. The Locomotive Engineer Review Board shall be composed of at least three employees of Federal Railroad Administrator selected by the Administrator. So your Locomotive Engineer Review Board shall be committed by at least three employees of the Federal Railroad Administrator selected by the Administrator. 24403. 24403 petition requirements. To obtain a review of the railroad decision to deny certification, deny recertification, or revoke certification, a person shall have file a petition for review shall comply with this section. Each petition shall be in writing, be submitted triplicated to the docket clerk, Federal Railroad Administration, 407th Street and South 407th Street, Southwest, Washington, D.C. 20590, containing all the available information person thinks to support the person believes the railroad acted improperly, including the petitioner's full name, the petitioner's current mailing address, the petitioner's daytime telephone, the name and address of the railroad, and the facts that the petitioner believes to constitute improper action by a railroad, specifying the locations, date, identities, and all persons who were present involved in railroad actions to the degree known as the petitioner. Explain the nature of the remedial action sought, be supplemented by a copy of all written documents of petitioner possession of the document of the railroad decision. And be filed in a timely manner a petition seeking review of the railroad decision to deny certification or recertification filed by the Federal Railroad Administrator more than 180 days after the date of the railroad's denial decision will be denied as untimely. A petition seeking a petition seeking review of the railroad decision to revoke certification in accordance with the procedure required in 24307, filed with the Federal Railroad Administration more than 180 days after the date of the railroad revocation decision will be denied as untimely. 24405, processing qualification review petition. Each petition shall acknowledge in writing the Federal Railroad, and the acknowledgement shall contain the docket number assigned to the petition. Upon the petition, the Federal Railroad will notify the railroad it has received a petition provided by the railroad and a copy of the petition. The railroad will be given a period of not exceeding 30 days to submit the Federal Railroad Administration and any information that the railroad considers pertinent to the petition. A railroad submits such information shall identify the petitioner, name, and the docket number of the review proceedings, and provide a copy of the information but submitted to FRA petitioner. Each petitioner will be and referred to the Locomotive Engineering Review Board for a decision. The board will determine whether the denial, revocation, certification, recertification was improper under the regulation based on an incorrect determination of the person failed to meet the qualification requirements of these regulations. Any grant or deny of petition accordingly, the board will not otherwise consider proper. The board will not otherwise consider the priority of the railroad decision, i.e., it will not consider whether the railroad properly applied its own more stringent requirements. Notice of the decision will be provided written to both petitioner and the railroad. The decision will include the findings of the fact of which is based. 24407, the request of the hearing. Adversely affected Locomotive Engineer Review Board decisions. Either the petitioner before the board of the railroad involved shall have the right to administrative proceedings as prescribed in 24409. Okay, so your adversely affected Locomotive Engineering Review Board decisions, either a petitioner or before the board or the railroad involved, and should have a right to the administrative proceedings as prescribed in 24409 to exercise the right of the adversely affected part party shall file with the docket clerk of the written request within 20 days of the service of the board decision of the party. The result of failure to request a hearing without a period provided by the paragraph of a section is that the locomotive engineer review board will constitute a final agency in action. In part of the Alex, the request of the hearing of the person shall submit a written request of the docket clear containing the following: the name, address, telephone number of the respondent, the requesting party, designated representative, if any, the specific factual issues, industrial rules, regulations, laws, and the requesting party eligibles needed to be examined in connection with the certification decisions in question. Signature of the requesting party representatives, if any, upon receipt of the hearing request complies with the paragraph of this section. The Federal Railroad Administration shall arrange the appointment of the presiding officer, who shall schedule the hearing of the earliest practical date. 24409. The administrative hearing of the locomotive engineering qualification petition shall be conducted by the presiding officer, who can be any person authorized on the administrative, including the administrative law of judge. Presiding officer may exercise the powers of administrative to regulate the conducting hearing of the purpose of achieving prompt and fair determination of all materials, issues, and controversy. The presiding officer shall convey presiding over the hearing. The hearing shall be de novo hearing to find the relevant facts, determine the correct application as the part to the facts. Presiding officers may determine that there is no genuine issues covering the sum of all materials, facts, limited evidentiary proceedings, any issues, material facts is which the genuine dispute. The presiding officer authorizes the discovery to types of the quantities within presiding officer's description contributing a fair hearing within unduly burdening the parties. Presiding officer may impose appropriate non-monetary sanctions, including limitations as to the presentation evidence issue, and any party with willful failure to refuse will comply with the approved discovery request. Each petition, motion, and the response or otherwise authorized required documentation shall be signed at the party filing the same. The duly authorized official officer representative of record may be any of the person if signed by another person, and the reason for these must be stated power of the attorney, other authority authorized and such other persons to subscribe. The document was to be filed with the document the signatures of the person person subscribing any documents constitutes a certification. He or she read the document the best of his or her knowledge. Information shall believe of every statement contained in the document is true, and no such statements as misleading that is not interposed or delay to be delay or to be vexatious. After the request of the hearing of the filing is filed, all documents filed and served upon one party must be served upon all parties. Each party may designate a person upon whom they served, whom service is to be made with the specified law, regulations, directive of the presiding officer. If party does not designate a person upon whom service is to be made, then the service may be made upon any person having subscribed to the submission of the party having being served, unless otherwise specified by law, regulation, directive of the presiding officer. The proof of service shall accompany all documentation with the tender filing. If any documentation initiating filed to serve the proceeding, if any subsequent compliance with the application law, regulation, directive of the presiding officer may strike, dismiss, or part of the such documents required in the amendments. Any part of the proceeding appear to the heard in this person, any authorized representative, any party to proceeding and may appear and be heard in person by any authorized representative. Any person testifying at a hearing deposition may be accompanied by a represented or advised by an attorney, or other representative may be examined by the person. Any party that may request counsel consolidated separate from the hearing of two or more petitions by motion of the presiding officer when they arise to the same similar facts of the material matters or for any reason deemed efficiently heard together. Except for provided as 24407 on this part of the paragraph U4 of this section, whenever the party of the right is required to action within the period prescribed by this part by the law and regulation directive of the presiding officer may extend such a period with or without notice for good cause be provided another party is not substantially prejudiced by such extension. A request is extended at the period which has already expired by the denied untimely. Okay, an application for the presiding officer for an order ruling not otherwise specifically provided in this in this part, but shall be by motion. The motion shall be filled with the presiding officer in written served to all parties. All motions, unless during the hearing, shall be written. Motions during the hearings may be made orally by the record, except for that the presiding officer may direct oral motion be reduced in writing. Any motion shall be made. Any motion shall state the particular grounds. Therefore, relief on the order sought shall be accompanied by the affidavits of other evidence and desire relied upon them, which does not already be part of the record. Any matter submitted in response to the written motion must be filed when served within 14 days of the motion and within such other period as directed by the presiding officer's testimonies and witnesses as at the hearing shall be given under oath, and the hearing shall be recorded in verbatim. The presiding officer shall be given the parties of the proceeding the adequate opportunities during the course of the hearing of the presentation, arguments, the support of the opposition motions, objects, exemptions to the rulings of the presiding officer. The presiding officer may permit oral arguments of any issues in which the presiding officers deem appropriate, beneficial, any evidence argumented, received, preferred, oral shall be transferred. Oral shall be transcribed and made a part of the record. Of physical evidence of the written or argumented, received, and preferred shall be made of the record, except for the presiding officer may be authorized substitution of copies, photographs, descriptions, whom, when deemed to be appropriate, the presiding officer shall employ the federal rules of evidence to use the state court magistrates as general guidelines for introducing of the evidence. Okay, notwithstanding paragraph of the section of the of this section, all relevant probative evidence shall be received unless the presiding officer determines the evidence is unduly repetitive, so extensive, lacking in relevance that the omission would be impair the prompt order of the fair resolution of the proceeding. The presiding officer may administrate oaths and affirmations, issue subpoenas, and report as proved in 209(7) and of Part 209 of the chapter, adopting the need of the procedure of submission of the evidence written in the form. 4. Examine witnesses. The hearing. 5. Convey recess, adjourning, and otherwise regulate the course of the hearing. Take any other action authorized by the consistent provisions of this part permitted. The law may expedite a hearing, aid of the disposition of the proceeding. The petitioner before the Locomotive Engineering Review Board that the railroad involved in taking certification action, the Federal Railroad shall be parties at the hearing. All parties at the particular in the hearing may appear and be heard only on the behalf of the through early designated representatives. All parties may offer relevant evidence, including testimony, may conduct cross-examinations of the witness, may be required to make a record of the relevant facts. The party requested the administrative hearing shall be hearing petitioner. The hearing petitioner shall have the burden of proving its case and the preponderance of the evidence. Hence, there is a hearing petitioner. If the railroad is involved in taking certification action, the railroad will have the burden of providing a decision to deny certification or deny recertification or revoke certification. Was correct. Conversely, the petitioner before the Locomotive Engineering Review Board is hearing the petitioner. The person will have the burden of proving the railroad decision, denying the certification, denying the recertification, revoke the certification incorrect between the petitioner before the Locomotive Engineering Review Board, the railroad involved with taking the certification action. The party who is not a hearing petitioner will be respondent. Federal Railroad Administrative will mandatory party to the administrative hearing at the start of each of the proceedings. The Federal Railroad will be a respondent. The record of the proceeding shall be closed in conclusion with the evidentiary hearing unless the presiding officer allows additional time for the submission of additional evidence. In such instances, the record shall be open in such a time as presiding officer grants of the purpose. At the close of the record, the presiding officer shall prepare a written decision in the proceeding. The decision shall contain the finding of the facts, conclusions of law, as well as the basis of each concerning all material issues of the fact law presented on the record. Shall be served on the hearing of the petitioner all other parties. The proceeding. 3 is closed of the record by the presiding officer shall prepare a written decision, and 3 shall not become in final for 35 days after the issuance. Constitute final agency action unless the aggravated parties files an appeal within 35 days after the issuance. It is not presidentially 244. And any party aggrieved with the presiding officer decision may file the appeal, and the appeal must be filed within 35 days of the issuance of the decision of the Federal Railroad Administrative of the 407th Street of the Southwest Washington, D.C. 20590. A copy of the appeal shall be served on each of the party. The appeal shall set forth the objection, presiding officer decision, support of the reference to applicable law, regulations, specific reference of the record, no appeal with the timely filed. The presiding officer's decision constitutes a final agency action, and the party may file the reply to the appeal within 25 days of the service of the point appeal. The repeal of the supported references to applicable law, regulations of the specific reference of the record of the party relies on the evidence contained in the record. C. The administrator may extend the period of filing of an appeal of the response of a good cause shown to the provided that the written request of extension is served by the expiration of the applicable period provided in this section. The administrative sole discretion of the permit oral argument appealed on the administration own initiative written motion by any part of the administrative may grant parties the opportunity oral argument. Administrative may affirm the reverse, alter, modifying decisions of the presiding officer. Administrative decision to constitute final agency action. Alright, this is Appendix A of Part 240, the schedule of civil penalties. Once again, continued. Subpart B, the component elements of 240-101, the program failure to have a program is from $5,000 to $10,000 willfully. Programs fail to address the subject to 2,500 of willful violation, 5,000. Failure to follow the Appendix B, 1,000 to willful violation of 2,000. To resubmit when directed by the Federal Railroad Administration, 1,000, 2,000. Failure to have adequate precision of selection supervisors, 2,500 to 500. Failure to 240. That's 107 class of service, 2,400. Failure to designate a classes of services. Limitations: considered prior conduct records having procedure determination eligibility, 25 to 500. 5,000. Consider excluded data, 2,000 to 4,000. Alright, failure to provide timely review of the opportunities, 2,000 with $4,000 willfully. Furnishing motor vehicles records, 1,000 of willfully. Violation, 2,000. In the file of the request of a local record, there's 1,000 violation, 2,000 willfully. The NDR record, 1,000 of willfully. Violation of 2,000. Failure to request additional record, 1,000. 2,000. Failure to notify absence of a license, 70. The absence of license is 750, and with a willful violation of 1,500. Failure to submit a request in a timely manner, $750 or $1,500 willfully. Furnishing prior employment information, failure to take action required in making information available, 1,000 violation, 2,000 willfully violation. Failure to request records violation, 1,000 willful violation, 2,000. Criteria considered prior motor vehicle conduct, considered excluded data, 2,000 willful violation, 4,000 considered data of properly acted in response data is at 5,000 to 75,000 to 2,500 to 5,000 willfully. Considered operation rules, compliance of orders, failure to program procedures is $2,500 to $5,000. Considered substance abuse rules and compliance records, failure to have a program and procedures is $5,000 to $10,000 willfully. Failure to have adequate program procedures is $2,500 to $5,000. Failure to adequate procedures determine acuity, $2,500 to $500. Failure to have adequate procedures continuing education, $2,500 to $5,000. Procedures having training new engineers, $2,500 to $5,000. Failures to adequate procedures of testing knowledge at $2,500 to $50,000. Adequate procedures of documenting tests, $2,500 to $5,000. Failure to adequate procedures of evaluating skill performance, $2,500 to $500. Adequate documentation, skilling, testing, $2,500 for $500. Failure to have adequate procedures of monitoring performance implementation process, schedule. Failure to have adequate procedures of monitoring process, $2,500 to $5,000. Willfully. Implementation processing, schedule implementation, failure to select supervisors by a specified date, $1,000 to $2,000. Willfully. Identifying grandfathered engineers engineers, 20,000 to 4,000. Failure to issue certification to engineering, 5,000. 1,000 to 2,000, allowing uncertified person to operate, 5,000 to 10,000. Certifying with a complier subpart C, 2,500 to 5,000. Failure to issue certification of the engineer, 1,200. Designating a supervisor with a determination person known as the understands that this part of the 2,500 to 500 person can test the evaluation of engineers of 5,750. Person experience prescribed remedies, 2,500 to $5,000. Willfully certifying a person with a determining person meets eligible criteria, 5,000 to 75,000. Meet medical criteria, 2,500 to 500,000. Demonstrated knowledge, 2,500 to 500. Willfully. And person of demonstrating skills, 2,500 to 5,000. Certifying a person with certifying a person without determining the person completed training program, 2,500 to 5,000. Person meets the eligible criteria, 2,500 to 5,000. Time elapsed, 2,500 to 5,000. Procedures determination eligibility based on poor safety conduct. Selecting person lacking eligibility, 5,750,000. Failure to have a basis attacking action, 2,500 to 5,000. Ineligibility based on medical conditions. Selecting personal lacking power acuity, 2,000 to 4,000. Willfully, and failure to have the basis finding of the proper acuity, 1,000 to 2,000. Willfully, and for the follows: acuity exams performed by unauthorized person, $1,000 to $2,000. Willfully, failure to note and denied the devices achieve the acuity, 1,000 to 2,000. Failure to use devices needed the proper acuity, 1,000 to 2,000. Demonstrating knowledge, failure to properly determine knowledge, 2,500 to 5,000. Proper testing procedures, 20,000 to 4,000. Failure to document testing results, 1,000 to 2,000. Allowing person to operate despite testing failure is 2,500 to 5,000. Demonstrating skills, failure to properly determine knowledge, 2,500 to 5,000. All right. I'd love to start. These are the penalties. I want to move on to Part B. Alright, this is a part Appendix B.